A very good evening, dear students. Welcome to Bajirao IAS Academy, the Hindu News Analysis. So today is 7th May 2025 and today we have some very important and interesting topics for the discussion, and one by one we'll try to discuss all these important articles in a very detailed manner. And the first topic with which we are going to start this session is about judicial accountability. And this particular article has been given in the Hindu newspaper, and this is very important for your general studies paper 2. And in fact, this article has been given in the backdrop of Supreme Court's judgment on Article 200 of the Indian Constitution. And in fact, we all knew the context because we have discussed this several times. And Article 200 of the Indian Constitution talks about the options that the governor would have once a bill is passed in the state legislative assembly and send the bill to the governor for his or her assent. However, in the case of Tamil Nadu State Legislative Assembly passed several bills, and those bills were also sent to the governor for his assent. However, the problem is that the governor is not giving assent to the bills. Article 200 of the Indian Constitution clearly mentions that once a bill is sent to the governor for his assent, he would have the following options. So the first option, he would give his assent to the bill. So governor can give his assent to the bill, and governor can withhold his assent to the bill, and governor send the bill for the reconsideration of the state legislative assembly, and governor can also reserve the bill for the presidential assent. So these four options that every governor would have under Article 200 of the Indian Constitution. However, if governor chooses to send the bill for the reconsideration of the state legislative assembly and state legislative assembly passed the same bill with or without amendments, it is an obligation on the part of the governor to give his assent to the bill. However, in this case, what happened was the governor sent certain bills to the state legislative assembly for reconsidering them. However, the state legislative assembly again passed those bills and sent to the governor for his assent. So instead of governor giving his assent to the bills, governor reserved the bills for the assent of the president. Right? So because of this particular reason, Tamil Nadu state government has approached the Supreme Court. So Tamil Nadu state government approached the Supreme Court telling that, so if bills are not becoming a legislations or laws, how can the state administration and governance would be carried out? Right? So on this pretext, Tamil Nadu government has approached the Supreme Court, and Supreme Court here clearly mentioned certain timelines within which governor and president must give his assent to the bills. However, with respect to governor, the Supreme Court has set a certain time limits. For example, the governor must give his assent to the bills in 1 month and to certain bills in 3 months, and even if any bill is reserved for the assent of the president by the governor, so those bills should also be given assent by the president within 3 months. However, the problem here is that Indian Constitution is silent, particularly Article 200 of the Indian Constitution is silent on the time frame within which a governor or president must give their assent to the bills. However, the Supreme Court has delivered this judgment using its extraordinary powers under Article 142 of the Indian Constitution. So we have several times discussed what is Article 142. So Article 142 talks about the power of the Supreme Court to do complete justice in any matter by passing certain decrees or orders. So that is what Article 142 is specifically talks about. So after this judgment has been delivered by the Supreme Court, the judiciary was criticized by some individuals or legal experts from both legislature as well as the executive as well. And in fact, the Vice President, Mr. Jagdeep Dhankar, termed this judgment of the Supreme Court as a nuclear missile attack on the legislature and the executive also. So this also brought up the issue of the judicial overreach. This also brought up the issue of judicial overreach, which has been clearly violating the separation of powers. And in fact, Indian Constitution has talked about the separation of powers. However, it is not strict separation of powers, but Indian constitution still talks about the separation of powers, right? So in this backdrop, a detailed article has been given in the Hindu newspaper about how judiciary maintains accountability, right? So I hope you have understood the context in a very detailed manner. So recent comments by Vice President Jagdeep Dhankar, so they have actually resulted in a constitutional and political debate all across the country regarding the role and the powers of the judiciary with respect to the executive. And in fact, there are a lot of concerns, and these concerns were primarily raised by his remarks calling judges as super parliament. So he called judges as super parliament because judges or the judiciary can do anything under Article 142 of the Indian Constitutions, right? So Supreme Court or the judiciary can do anything to do complete justice in any matter under Article 142 of the Indian Constitution, and that's why Vice President Jagdeep Dhankar called the judiciary or judges as the super parliament. He called the judiciary or the judges as the super parliament because, in India, to pass a laws, to make legislations, we have a legislative body. So we have a legislative body, that is parliament, and parliament is actually filled with individuals who are directly elected by the people. So however, here the Supreme Court or the judges are acting as a super parliament. So therefore, ultimately, Vice President questioned the power of the judges, powers of the Supreme Court, and in fact, in this particular judgment, the Supreme Court has directed the President to give his assent to the bills within just 3 months. So thereby, judges are not accountable under the law. So he said that judges are not accountable under the law, unlike the MPs or the government officials. Right. So therefore, in this context, we'll try to understand very briefly what is a separation of powers which is provided in the Indian Constitution. And in fact, so in India, we don't have a strict separation of powers like US. So because US provided for the strict separation of powers. Instead, we have a strict separation of powers along with the checks and balances as well. So however, the doctrine of separation of power is a cornerstone of Indian Constitution. So we have different branches of the government, for example, executive, legislature, and the judiciary. And each branch of the government should not intervene in the powers and functions of the other branch of the government. For example, if we have a judiciary, and judiciary is a one branch of the government, and judiciary should not intervene in the powers and functions of the parliament. So this is what the separation of powers essentially talks about, and in fact Indian Constitution is also provided for the separation of powers, and in fact it is considered as a cornerstone of the Constitution. However, as I have already told you, there are 3 branches or 3 organs of the government, that is legislature, executive, and judiciary, and each of these bodies functions independently. However, subject to checks and balances. So these checks and balances are also provided by the Indian Constitution because we don't have the complete separation of powers. And in fact, any overreach by one organ into the other domains, so that will actually undermine the constitutional governance. For example, executive interfering in the functioning of the parliament, or legislature interfering in the functioning of the judiciary. So that is not what is desired here. Right? So any overreach by any organ into others' domain would seriously undermine the overall constitutional governance. And in fact, one of the judgment of the Supreme Court, that is L. Chandrakumar versus Union of India case 1997. So in this particular judgment, the Supreme Court has clearly held that even the independence of the judiciary is fully secured because of the principle of separation of powers. Right? So in fact, independence of the judiciary is part of the basic structure doctrine that was given by the Supreme Court in Keshwanand Bharati judgment. However, the independence of the judiciary is also fully protected or secured only because of the principle of separation of powers. So therefore, no organ of the government, no branch of the government should violate the principle of separation of powers, should involve or interfere the powers and functions of the other organs of the government, and this is what the Supreme Court has rightly held in L. Chandrakumar versus Union of India case 1997. And in fact, if we look into the constitutional provisions, Article 50 of the Indian Constitution, I hope you have gone through the Directive Principles of State Policy, and Article 50 of the Directive Principles of State Policy so also talks about the separation of the judiciary from the executive. So this is also in line with the principle or doctrine of separation of powers. Right? So if any time judges try to exercise their powers arbitrarily, so if they are trying to interfere with the functioning of the other branches of the government, it shall be considered as a gross violation of Article 50 of the Directive Principles of State Policy, because Article 50 of the Directive Principles of State Policy talks about the separation of judiciary from the executive. And in fact, any judge try to exercise their powers arbitrarily, then the government may initiate a process of removal of the judge concerned. Right? So this is what is called as, this is an example of checks and balances. Right? Checks and balances. So therefore, Indian Constitution has provided a mechanisms for both separation of power as well as the checks and balances as well. So however, even if we have three different branches of the government, no branch is considered as supreme, right? So no branch is considered as supreme, but ultimately the constitution is the supreme, or constitution is the supreme law of the land. So when we talk about the constitution and the supremacy of the constitution in India, the rule of law and supremacy of the constitution are considered as the foundational doctrines. So apart from rule of law and the constitution, no other branch of the government is considered as supreme, even if it is judiciary also. And in fact, president, governors and judiciary, everyone are bound by the constitutional provisions and rule of law. So no one should be above law. So everyone should be treated equally by the law. So that is what is rule of law. And in fact, no authority is beyond the scrutiny if it violates the constitutional boundaries also, whether it is executive, judiciary or legislature. So here it is very, very clear that the constitution and rule of law are supreme, but no other branch of the government. Constitution has clearly provided for the separation of powers, and constitution has also guaranteed certain powers and functions to these respective branches of the government. However, if one government try to act arbitrarily and interfere in the functions of the other branch of the government, that amounts to the violation of the principle of separation of powers, and that could trigger checks and balances as well. However, if you carefully look into the Vice President's remarks on the judges utilizing Article 142 of the Indian Constitution to pass orders to the President, and in fact, Parliament is a body which consisting of elected by the individuals who are directly elected by the people. And Parliament in India have the legislative powers. And in fact, Parliament is the body which is having the sovereign powers to make laws throughout the country. However, but this does not mean that the judiciary's constitutional review powers encroach upon the Parliament's supremacy. And in fact, it is clearly mentioned here that it is true that Parliament has the power to make laws. And in fact, Parliament is consisting of MPs who are directly elected by the people. So despite that, in order to curb the arbitrary powers of the Parliament to make laws which are against the constitutional provisions, the Supreme Court of course invoke the provision of judicial review, so that to ensure the constitutionality of the laws passed by the Parliament. However, this cannot be treated as encroachment upon the powers of the Parliament or the legislature, because it is very, very important that the laws which are passed by the Parliament must be in conformity with the constitutional provisions. They should not violate the constitutional provisions. And that is the reason why in 1973 Keshwanand Bharati judgment, the Supreme Court has come up with an innovative doctrine called the basic structure doctrine. And in this basic structure doctrine, a certain provisions of the Indian Constitution or certain novel features of the Indian Constitution have been included. So Parliament should not amend those parts of the Indian constitution. For example, federalism is part of the basic structure doctrine, rule of law, parliamentary form of government, free and fair elections. So all these different things are part of the basic structure doctrine. And in fact, judiciary is also considered as the guardian of the Indian constitution, right? So in fact, judiciary has actually plays a very, very important role, very crucial role. So when it comes to upholding the Indian constitution and constitutional provisions, so because of that reason, judiciary acts as a guardian of the constitution, ensuring that no law violates the constitutional limits. And in fact, this question was already asked by the UPSC. Who is considered as the custodian of the Indian constitution? The Supreme Court is considered as the custodian of the Indian constitution. Now, in this context, what will be the judiciary's role regarding the presidential assent? So as I have already told you that Article 200 of the Indian Constitution clearly mandates that there are certain options in front of the governor when a bill is presented before him. So one of the option is reserving the bill for the assent of the president. So in this case, in recent judgment of the Supreme Court has clearly mentioned that the president must give his assent to the bill within 3 months. Right? So that's where this debate has been started criticizing judiciary, violating the principle of separation of powers. And in fact, the President of India under Article 52 is the constitutional head of the state. And therefore, the President must act as per the aid and advice of the Council of Ministers under Article 74 and 78 of the Indian Constitution. However, President is elected by the provisions contained in Article 54 and Article 55 of the Indian Constitution, and the election of the President will make India a truly republic state. However, so if there is an undue delay when it comes to giving assent to the bills by the President or the Governor, then judiciary is expected to intervene and protect the popular sovereignty. Because ultimately it is important that the elected government must make laws for the smooth conduct of the governance, whether at the central level or at the state level. If governor or the president arbitrarily not giving assent to the bills, or they are indefinitely delaying assent to the bills, then of course the judiciary would intervene to protect the popular sovereignty of the country. So this is what the author has been talking about. However, here a few things that we have to understand. There is an interplay between the judicial independence, popular sovereignty, and judicial activism. And in fact, judicial independence is very, very important here, because a judicial independence ensures that the basic structure doctrine is upheld. So basic structure doctrine essentially means that the executive and the legislature would not violate the basic principles of the Indian Constitution. They would not pass arbitrary laws. They would not take arbitrary policy decisions. So therefore, judicial independence is very important to uphold the basic structure doctrine of the Indian Constitution firstly. Secondly, judicial independence is also shielded from arbitrary executive and the legislative interference as well. However, when we talk about the popular sovereignty, so popular sovereignty is also another foundational principle of any democracy. So in this context, the judiciary actions such as setting deadlines for the president or governors to give assent to the bills passed by the state legislative assemblies or the parliament, so it essentially aims to uphold the larger public interest and also the constitutional compliance of the constitutional heads at the level of state and also at the central level. And Article 142 of the Indian Constitution, this is very, very important article, because Article 142 of the Indian Constitution talks about the power of the Supreme Court to do complete justice in any matter. However, if Article 142, if Supreme Court uses this article, if Supreme Court applies this particular article, so that is being viewed as either judicial activism or the judicial overreach. However, Article 142 empowers the Supreme Court to pass certain orders to do complete justice in any matter. However, such provisions actually underscore Supreme Court's role in filling the legislative and executive voids. And it is also true that Parliament is not able to pass legislations on several important matters as well. This is evident from the fact that in 1997, Supreme Court has issued the Vishaka Guidelines. So these Vishaka Guidelines talking about protection of a woman at the workplaces. However, since there is a legislative or executive vacuum, the Supreme Court has intervened and it has filled the vacuum. So therefore, Article 142 or anything which has been brought up by the Supreme Court which may be considered as a judicial activism, so they underscore the court's role in filling legislative and executive voids when constitutional mechanisms are silent. So Article 200 of the Indian Constitution, right? So I have told you that what are the options that the governor would have once the bill is passed in the state legislative assembly and the bill is sent to the governor or the president for his or her assent. And in fact, Article 201 of the Indian Constitution, so it clearly states that when a bill is reserved for the consideration of the president, so president may assent to the bill or withhold his assent to the bill. Anything could happen, right? So these are important articles. So however, here we need to understand what is the difference between judicial review, judicial activism and judicial overreach. So these terms you might have heard, and it is very important to understand these three terms. So when we talk about the judicial review, so judicial review is a mechanism that is already provided by the Indian Constitution. But remember that Indian Constitution nowhere mentioned this term judicial review. So it is inherently provided in the Indian Constitution under Article 32 and also Article 13. So judicial review actually means that the power of judiciary to examine, to review the constitutionality of legislative enactments and also the executive orders. So this is applicable for both central and the state government laws. For example, imagine that the parliament has passed a law on a certain issue, and if Supreme Court believed that that particular law passed by the parliament violates the constitutional provisions, then the Supreme Court has the power to declare such a law as unconstitutional, null and void. So one such example was a striking down of the Section 66A of the IT Act, because it has been providing some arbitrary powers to the law enforcement agencies when it comes to arresting and questioning the individuals. So therefore, the Supreme Court, on the pretext of violating the fundamental rights of the individuals guaranteed under the Indian Constitution, Supreme Court had struck down 66A of the IT Act previously. However, what is a judicial activism? So we have understood judicial review. So what is a judicial activism? So judicial activism can be equated with the proactive nature of the judiciary. So judiciary would be acting in a much more proactive manner, or it has been playing a proactive role. For example, imagine that there is a judicial vacuum or executive vacuum. So in order to fill the legislative and executive vacuum, so in order to fill the vacuum, the judiciary has been coming up with certain guidelines. One example is Vishaka Guidelines, right? So public interest litigation is also an example of judicial activism. So judicial activism ultimately highlights the proactive role actually played by the Supreme Court or the judiciary in the protection of the rights, civil liberties of the individuals, and also the promotion of social justice or overall justice in the society. So one example was Supreme Court previously invented several mechanisms such as the public interest litigation and also taking up cases suo motu on its own without anybody filing a case. Supreme Court could take up the certain cases on its own. So what is a judicial overreach? So we should also understand and differentiate the judicial overreach from other two different mechanisms. So when judiciary oversteps its traditional role or its traditional jurisdiction and it start encroaching upon the powers and functions of the legislature and also executive, so that might be considered as the judicial overreach, right? So when judiciary oversteps the powers given to it, so it also started interfering with the functioning of the legislative and executive organs of the government. So in this case, it is defined as the judicial overreach. The example was higher judiciary deciding on Diwali firecrackers, on even ban on liquor on highways. So these are the examples of judicial review, judicial activism, and judicial overreach. So I hope you have understood this. And next, very important topic. So this is important, and this particular topic has been given in the Hindu newspaper, and this is very important for your General Studies paper 2 mains examination, particularly in the governance section. So because in the governance section there is a topic called role of civil services, civil servants or civil services in a democracy. So in fact, civil services are considered as the steel frame of India, but civil services have also been facing certain challenges in the present society or present governance architecture. Now in this article we'll understand what is the importance of civil services and what are the challenges that the civil services have been facing in India, and what are the reforms that are required to be undertaken so that civil services can be reformed in a letter and spirit. So in fact, Civil Services Day, so while delivering a speech by Cabinet Secretary T.V. Somanathan, so he actually highlighted the indispensable role that civil services play in upholding the Indian democracy. And in fact, it is also said that the Indian civil services plays one of the crucial role, and it actually played indispensable role when it comes to upholding Indian democracy. So how it played a very important role, so we'll understand that aspect as well. However, while praising their contributions to further strengthening Indian democracy, and in fact they have substantially contributed to the governance, to the elections, and even the development administration. So T.V. Somanathan, he also acknowledged the deep-rooted challenges that actually impede the efficiency and the credibility of the civil services. However, in the context of the evolving needs of the governance or the changing governance dynamics, because we have been emphasizing on minimum government and maximum governance. So this has been indicating that there has been evolving governance needs for civil services in India. So it is being said that the civil services as of now stands at a critical juncture, and there is a need for a reform. So reform is not just desirable, but it is imperative. It is important for further improving the existing governance architecture in India, and also make sure that everyone would receive the benefits or would receive the governance benefits. So if you carefully look into the evolution of the civil services in India, so civil services in India dates back to 1858, right? So it was date back to 1858 when a British established Indian civil services based on the merit system to manage the administrative functions. Right? So in order to manage the administrative functions based on the merit system, the British established Indian civil services. However, after independence, the role was taken over by the Union Public Service Commission, which has been conducting the examination based on the merit to select candidates for the civil services. However, UPSC since then became a cornerstone of merit-based recruitment in India. However, civil servants are considered as a central or a cornerstone because they have been playing a very important role, for example, conducting free and fair elections, enriching the democratic credentials of our country. And in fact, you could see how the democracy has been taken to the grassroots level in India, right from India's independence. And in fact, in most of the third world countries or the post-colonial societies, democracies were not sustained, right? So, but India is able to sustain its democracy and its democratic credentials, and every individual in India respect democracy and the free and fair election process. And in fact, in most of the elections that India has seen, the transfer of power is very smooth, right? So therefore, civil servants would actually play a very important role when it comes to conducting free and fair elections. And it also ensures continuity of governance during the president's rule in states. For example, Article 356 of the Indian Constitution talks about imposing president's rule in a particular state. Now, in that case also, civil servants play a very important role in ensuring continuity in the governance. Apart from that, they also advise the political executive on policy formulation. So by policy formulation, despite government's changes, so you could see the policy continuity as well. And in fact, India is a country which has been facing a lot of social and economic issues. So in this backdrop, in order to implement the welfare programs, welfare schemes for the benefit of the downtrodden, for the benefit of vulnerable and marginalized sections, civil services play a very, very important role. And similarly, they also maintain or manage day-to-day administrative functions such as public service delivery and even regulation enforcement as well. And you could also see the timeline of the recruitment of the civil servants, and this is also important for your examination as well. And in fact, in 1864, Satyendranath Tagore, so he was the brother of Rabindranath Tagore, became the first Indian to clear the exam that was held in London. Right? So you could get some other important insights. So please kindly go through this. And what are the major challenges that the civil servants nowadays have been facing? So civil services have been facing certain critical issues or certain challenges. For example, so neutrality is an important foundational value of civil services. So what does neutrality actually mean? That in a democracy, different political parties comes to power. However, civil servants are known as permanent executive, but the politicians are not called as the permanent executives. So since civil servants are called as a permanent executives, government comes and a new government, every time government changes, it is very important that the civil servants should be neutral, they should be non-biased. So therefore, the foundational trait of civil services is a neutrality, but this neutrality as a value has been fast declining. So this is the major challenge that the civil servants have been facing. And in fact, in nowadays, what has been happening is that bureaucrats or the civil servants are increasingly aligned with different political parties and the political ideologies and the political interests. So that could certainly threaten the democratic credentials of our country. And that would also dent the image of the civil servants as a neutral public servants. So therefore, it ultimately compromises the integrity of civil servants and also the impartiality that has been expected from them. Secondly, political interference is also another major problem that the civil services has been suffering with. So political interference essentially means that the politicians very often interfere in the functioning of the civil servants. So ultimately, it would result in obstruction in the functioning of the civil servants. For example, frequent and arbitrary transfers. For example, Ashok Khemka, he is known as the honest civil servant in India because he was transferred number of times in his entire service. So therefore, frequent and arbitrary transfers by the politicians, especially for the upright officers, and the best example is Ashok Khemka. So that would discourage the independent functioning of the civil servants. And apart from that, the administrative decisions are often influenced by the political calculations rather than the public interest. So this is also another major problem. And personal interest is being prioritized over the public interest, right? So in fact, the administrative decisions are very often or much likely influenced by the political calculations of the political parties or the individual politicians rather than the larger public interest. And that's where the civil services has been facing several problems because of the political interference. And in fact, civil services is very often criticized as being generalist. However, generalist bias and there is a lack of domain expertise. So, we are moving towards the fourth industrial revolution. So we are moving towards the fourth industrial revolution. We are started emphasizing on digital governance, e-governance, right? So in number of domains, the civil servants are considered as generalists. So they are being recruited to the number of ministries. They work under number of ministries. However, nowadays require a domain expertise, but domain expertise is lacking. So this is another major problem. And Indian civil services, Indian bureaucracy is considered as a generalist model where officers rotate across sectors, limits the capacity to address the increasingly technical and specialized challenges they come across during their service. And in fact, this also very often results in suboptimal policy design and implementation on the part of these civil servants. And even corruption is also another major problem that the civil services has been facing in India. And in fact, the corruption exists at the multiple levels. So despite existence of mechanisms such as Vigilance Commission, Prevention of Corruption Act, many cases of corruption go unpunished and thereby ultimately eroding the trust in the civil servants. So what are the reforms that are required for the future ready civil services in India? So there are certain reforms which are actually required to change or to ultimately reform the civil services. So firstly, insulation from the political pressure. So we have understood that the political interference is one problem that the civil services have been facing. So therefore, insulation from the political pressure is one thing that we could actually done here. So for that, there is a need to ensure rule of law and constitutional governance. The civil servants must be granted with a reasonable degree of autonomy in postings, tenures, and the transfers as well. So here, the civil servants must be provided with the security of tenure. Secondly, there is a need for a shift from procedures to outcomes. So as of now, civil services have been excessively emphasizing on procedures rather than the outcomes. However, instead of emphasizing or looking into the procedures, there is a need to transition to outcome-based monitoring to align the public service with actual societal impact. So similarly, lateral entry of the domain expertise. And in fact, the government has been planning for a lateral entry of the domain expertise instead of completely relying on the generalist civil servants. Right. So in fact, the government already recruited the individuals under the lateral entry scheme. So therefore, introducing professionals from outside service at senior levels can actually bring perspectives and also technical proficiency into the civil services, and that could also benefit the civil services in the long run. However, to bringing in domain expertise through lateral entry actually complements the institutional knowledge of career bureaucrats and also enhance the governance quality overall. And similarly, in order to plug corruption, transparency and accountability is very, very important into the civil services. So therefore, internal performance audits must be done, independent vigilance mechanisms should be established, and digital record administrative decisions must be taken to strengthen the accountability within the system. So these reforms must be undertaken to reform the civil services and also make sure that the civil services is protected from the challenges that it has been facing. And in fact, so how can we enhance the efficiency of the bureaucracy? So a merit-based recruitment that is already being undertaken, performance-based promotions to the civil servants, and protection from the political pressure, because political interference is one of the main problem that has been hindering the civil servants from performing their duties. And domain specialization is very important. Lateral entry could address this, and enhanced data infrastructure is also very important. Interdepartmental coordination and even the comprehensive reform or 360-degree evaluation of the civil servants on a regular basis. And in fact, building public trust should also an important aspect under the civil servants. So under the civil services primary duty. So there are certain values which are considered as the foundational values of civil services. For example, integrity is a foundational value, impartiality, non-partisanship, objectivity, tolerance, and dedication to public service. So these are a certain foundational values that every civil servant should possess. And in fact, there are examples are also given for the same. And this could be very important for your ethics as well, because you need to write what does integrity means for a civil servant, right? So integrity means for a civil servant is actually the soundness of moral principles and uncorrupted character, uprightness, honesty, and sincerity, right? So certain examples are also given, and kindly pause the video and go through this as well. So next important article is India-UK Free Trade Agreement. So it is a historic moment because India and UK have signed a free trade agreement. So both these countries have signed a free trade agreement, and because of that reason it is considered as a historic movement, because nearly after 3 years of negotiations, both India and UK have signed a free trade agreement. So we all knew that UK is no longer part of the Brexit arrangement, right? So it is no longer part of the Brexit arrangement because it came out of it is no longer part of the European Union, because it came out of the European Union and it wanted to have a free trade agreement with India. So one thing that we should understand here is that India is as of now having a trade surplus with the United Kingdom, and this free trade agreement will also benefit India heavily. So India and UK have signed a free trade agreement after nearly 3 years of negotiations between these two countries. And in fact, it is being said that this free trade agreement between India and UK would reduce tariffs by at least 90% of the goods. And in fact, this free trade agreement between India and UK aims to boost trade, investment, job creation and innovation in India and UK also. Apart from that, this free trade agreement between India and UK comes at the backdrop of the global trade uncertainty, and therefore it marks a major economic collaboration between world's 5th and 6th largest economies. Now understand, India is a world's 5th largest economy in terms of GDP, and UK is the 6th largest economy in terms of GDP, right? So therefore it is an economic collaboration between world's 5th and 6th largest economies. And in fact, it was earlier expected that a free trade agreement between India and UK would be concluded by Diwali 2022. However, even though it was dragged, but finally the free trade agreement has been concluded or finally achieved in 2025. However, UK became the first Western trade partner, right? So first among the Western trade partners, because understand that we also wanted to have a free trade agreement with number of other countries. For example, we wanted to have a free trade agreement with Canada and European Union and even USA as well. So among all these different countries that India wanted to have a free trade agreement, UK became the first country that has signed a free trade agreement with India. And in fact, UK beat US, European Union, for that matter Canada also, sealing free trade agreement with India. So therefore it is considered as a strategic win for both India and UK. And in fact, so this free trade agreement between India and UK puts India in a much more stronger position for ongoing trade talks with US and also European Union and even Canada as well. And in fact, it is also said that this UK free trade agreement would be considered as a benchmark for a future agreements with most of the European countries as well. And in fact, you can see on this image the products on which the duty will become zero. So there are number of sectors, number of products on which the tariff would become, the duties would become zero. So that is going to benefit the trade between India and UK, and it is going to benefit both these countries as well. However, it is expected that this free trade agreement would benefit India more because India as of now is having a trade surplus with UK, and growing India's manufacturing capabilities would potentially add to the India's increasing trade surplus with all these different countries. And in fact, it is also a good a signal, a good message for other European countries including US as well to sign a free trade agreement as early as possible with India. So however, when we talk about certain highlights of this free trade agreement between India and UA, so in 2024 the total India and UK trade stood at 42.6 billion euros, and in fact UK exports 17 billion euros and imports from India at 25.5 billion. So that means India exports 25.5 billion worth of goods to UK. However, UK exports to India 17.1 billion worth of goods. And in fact, India is also ranked as the 11th largest trading partner for UK in the year 2024. So you just have to remember this. So For UK, India is the 11th largest trading partner, and the bilateral trade between India and UK is 42.6 billion US dollars. So tariff reductions and market access is also another important area of strong cooperation, because when we talk about the tariff reduction and market access, this is going to benefit both India plus UK. So both these countries would get benefited by this. So when we talk about the benefits that accrue to the India through this free trade agreement, 99% of Indian exports to UK will enjoy duty-free access. Right? So 99% of India's exports to UK will enjoy duty-free access, and in fact it will also boost labor-intensive sectors in India such as textile industries, marine products, leather, footwear, sports goods, toys. So all these industries are considered as the labor-intensive industries, and this will also result in large-scale employment generation in India and further boost to the manufacturing sector. However, through this free trade agreement, what are the major gains to the UK? So India will slash duties on 90% of the tariff lines, and 85% becoming fully tariff-free within 10 years. Apart from that, the lower Indian tariffs on whiskey, medical devices and advanced machinery and lamp to make UK exports more competitive. So services and workforce mobility. So in fact, this particular deal would include increased quotas, because Indian workers are also working in UK, so that they are taking up employment opportunities in UK. So there are certain sectors where Indian workers are working in UK. So therefore in UK that would enhance the labor mobility and also service trade cooperation as well. And Indian workers in UK will receive 3-year exemption from the social security payments. So they need to pay the social security payments if they are working in UK, so that thereby reducing the financial burden and also improving the mobility opportunities. Right? So you can also go through the differences between the free trade agreement and preferential trade agreement and comprehensive economic cooperation agreement and comprehensive economic partnership agreement. So these are different agreements, so you can kindly go through with this. And in fact India has also signed a number of free trade agreements with other countries as well, so you can go through this as well.